regard to the nature of the litigation, we have addressed our
बताइए कि HDFC में उसने पूछा बैंक में था तो वहाँ भी आवरली है
the execution of the discharge voucher towards the full and final settlement between the parties would operate as a bar to invoke arbitration. Secondly, what is the scope and standard of justice that an application under Section 11, Clause 6 of the Act 1996 can be subjected to when a plea of accord and satisfaction is taken by the defendant. And thirdly, what is the effect of the decision of this court in re interplay between arbitration agreements under the Arbitration and Conciliation Act 1966 and the Indian Stamp Act 1899 on the scope of powers of the referral court under Section 11 of the Act 1996? Well, just quickly, what we have said is, thus, even if the contracting parties, in pursuance of a settlement, agree to discharge each other of any obligations arising under the contract, this does not ipso facto mean that the arbitration agreement too would come to an end unless the parties expressly agree to do the same. The intention of the parties in discharging a contract by accord and satisfaction is to relieve each other of the existing or any new obligations under the contract. Such a discharge of obligations under the substantive contract cannot be construed to mean that the parties also intended to relieve each other of their obligation to settle any dispute pertaining to the original contract through arbitration. Although ordinarily no arbitrable disputes may subsist after execution of a full and final settlement, yet any dispute pertaining to the full and final settlement itself, by necessary implication, being a dispute arising out of, or in relation to, or under the substantive contract, would not be precluded from reference to arbitration, as the arbitration agreement contained in the original contract continues to be in existence even after the parties have discharged the original contract by accord and satisfaction. Our final conclusion is like this. The existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant being one of quantum and not of liability, prima facie falls within the scope of the arbitration agreement. The dispute regarding accord and satisfaction as raised by the appellant does not pertain to the existence of the arbitration agreement and can be adjudicated upon by the arbitral tribunal as a preliminary issue. For all the foregoing reasons, we uphold and affirm the appointment of Justice K.A. Pooch, former judge of the High Court of Gujarat, as an arbitrator to resolve the disputes between the parties. But what is important in this judgment is that we have clarified our earlier judgment in Arif Azim. The clarification starts from para 126. We have explained how Arif Azim should now be construed or understood, more particularly in light of this pronouncement. And what is important is, just one paragraph very quickly, we are running late. Thus, we clarify that while determining the issue of limitation in exercise of the powers under Section 11(6) of the Act 1996, the referral court should limit its inquiry to examining whether Section 11, subsection 6 application has been filed within the period of limitation of 3 years or not. The date of commencement of limitation period for this purpose shall have to be construed as per the decision in Arif Azim. As a natural corollary, it is clarified that the referral courts, at the stage of deciding an application for appointment of arbitrator, must not conduct an intricate evidentiary inquiry into the question whether the claims raised by the applicant are time barred and should leave that question for determination by the arbitrator. Such an approach gives true meaning to the legislative intention underlying section 11 bracket 6 capital A of the Act and also to the view taken in re interplay. That's how we have decided. Thank you.
Very good.
With your lordship.
May I just give you lordship?
Everybody else, please circulate emails because once we breach the norm, then I cannot breach it only for seniors and I have to do that for everybody else. It completely destroys the system which I have put in place. Everyone who has a request, please send me an email. I'll look at it by the afternoon today.
No, this is not a listing request.
Mine is not a listing.
Anybody who does not have a listing request, some correction in an order, something is free to mention.
There's a matter coming tomorrow. We're asking the review today to be put with that tomorrow. That's a request.
That also has to go on an email. That's a listing.
I'll put it in the email. Put it in the email.
Listing, if it's on listing, please don't mention. Please put it in an email. I'll look at it in the afternoon today. I promise you I'll do that. It's the same thing. When was the impugned order passed?
Now my difficulty is because building may be demolished. Complaint could have been filed.
By 19th, right? So we'll list it tomorrow.
Your lordship, I'm just
I'll
seeking
list it tomorrow.
permission to
No,
circulate.
but you could have also said it in an email. Sorry. Circulate a rejoinder.
Circulate a letter in tomorrow's matter listed at item 26. And for the respondent, we just need
Too
some
late
time to
now.
come.
We'll see tomorrow, yes.
Because I'm mentioning a matter where I've already sent emails for us. Maloj, I've also sent
It will be
emails
dealt
this
with.
morning.
It will be dealt with.
This
Puneet,
morning
just
also,
make
Maloj,
sure.
I'll meet the.
Mr. Sure, Balam.
Manoj,
Very great.
just a query, would your lordship be taking the part third income tax matter or?
Just
would your-
wait. I've just told the court master. We'll tell you in a minute. Yes.
My lord, I'm sorry, I just one request. There's an order that your lordships had passed last week, my lord. It's an arbitration petition. Your lordship perhaps will recall, notes, I had made a submission that the pendency or the reference to arbitration will not impact any criminal proceedings that we might initiate. Because our recollection is my lordships had dictated that in court, my lord, but it's perhaps not reflected in paragraph 3, my lord.
No,
Your lordship,
we also said in the course of the discussion
Please, my lord.
that an arbitration will never affect a criminal prosecution.
But I made that submission, I think,
All right.
Your
We
lordship
don't have to
had
put
made that
something, we
observation.
don't have to put something, clarify something which is obvious.
very well.
So before we begin, what we're proposing to do is that we have the income tax partnered group. NEET is above that today. We'll at least open the NEET matter and then we'll see what to do with the partnered group. We'll hopefully start with the partnered group, but it might just have to wait until we open the NEET matter because there's some urgency in the NEET matter. Young students all over the country are waiting for the outcome of this matter. So, but we are not going to lose season of the income tax matter because we are now also mentally we are in the matter.
But may I suggest, since we have circulated something yesterday, it can be kept tomorrow also.
let's at least open the NEET matter today because, let's see the matter.
The others can be discharged, etc. Many are procedural matters, item 4, etc.
So what we are doing is,
Procedure.
seal number 1, for instance, is about bifurcating, we'll take up item 1. So it's bifurcating matters, etc. That will pass procedural direction.
For compliance like that, when your lordship
Right, we'll just, yes.
I'll point out.
Item 1 is not bifurcating. Item 1 is a batch of cases on fringe benefit tax.
Yes, the fringe
That will come on
benefit
some other day. Yes. The bifurcation is the gaming matter, I think, if I'm not mistaken.
Why is that listed for directions? Because item 1 is only listed.
There are two appeals.
All right,
and there
then
are other
item
transfer
1,
petitions.
right, the court master says that, we have to pass the usual procedural direction for appointing nodal counsel so that they prepare one common compilation. So tell us who will be the nodal counsel.
That's right. Mr. I'll give my AOR's name to your lordship's bench, and one from the department. So 2 of us can be there.
Is
give
there
me by
a
lunchtime.
compilation for the department? Is there a compilation for the?
Only for the petition.
So now tell us for the petitioners, who will be the nodal counsel?
I can volunteer.
Mr. Kunal Kishore can.
Ma'am, since you've already prepared.
Manisha Karya have already our compilation.
And for the department, Mr. Venkatraman, are you appearing in the one? You are appearing. Who will be the nodal counsel there?
Mr. Divakar.
Mr. Divakar. So Ms. Manisha Karya and Mr. Divakar will be nodal counsel. Usual orders. And prepare one common compilation duly indexed with written submissions in terms of our last circular. And file it by what date will you file it? Mr. Datar, by what date will you file the compilation?
Your lordship is posting it in August or July?
We'll post it in August, so we'll give you enough time to file the compilation. You can file the compilation including written submissions by the 31st of July and we'll place it in August. All right, so that seal number 1 is over. That way, we have just one compilation, otherwise it becomes impossible to.
Item 2, my lord, the canon matter, my lord, they have put a direction now. It has to be, bench has to be constituted, the lot of batch of matter there.
So here also, can we have one compilation, please?
Yes,
we can do a compilation.
Right, so who will be the nodal counsel?
I will.
Charanya will be the.
From our
right.
side, V. Chandrasekhar Bharti will be the
So.
panel counsel.
Charanya Lakshmi Kumar and Mr. V. Chandrasekhar Bharti. And can you prepare the submissions and compilation by 31st of July?
No, definitely.
Definitely.
Then we'll keep it in the first week of August and we'll take this up. Because a lot of matters across India are dependent on this.
Pending.
Thousands.
Thing is, my 3 member bench. Because this matter, the canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges. It'll be before this regular bench.
Yes,
It'll be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
Item 3 is the Google matter.
Manoj, I appear for Google. Your lordship recalls your lordship.
What we'll have to do is, are the compilations ready in Google?
Everything is done. Manoj, give dates in September.
Today,
Your
Mr.
lordship's
Sarve,
right.
only because we have the NEET matter and, literally lakhs of
No, Manoj,
all over the country are waiting for the outcome of this matter.
No, in September, Manoj, give dates in September.
Probably in the first week of September, so that we can conclude.
Manoj, a little later, I have the Indus Valley dispute before the neutral expert in September.
Second week of September, Marathon.
After 15th, Manoj. After 15th, any day.
Submissions have not been received, the court master says, so you'll have to email them.
That will make sure, Manoj, are sorted
All
out.
right, why don't you give us on the side of Mr. Sarve one nodal counsel?
Lordships,
Yes.
we have filed it. We filed it on the 3rd of October. We'll file it again. We'll send an email again. It's been filed.
All right, who's the nodal counsel on your side?
Mr. Rohit Chandelier, he's the nodal counsel.
Mr. Shandila, and what about Mr. Venkatraman, your side?
Already said in
We've already appointed nodal counsel. All right, then make sure that is filed by the 31st of July. All right.
Yes.
Gaming matter.
This again, Manoj, is the gaming matter.
Are these absolutely ready for
Union Marots has filed its counsel. Lordships had directed violations to be filed, appointed nodal counsel that has not.
We can do it one of each.
So we set down 31st of July for completing the filing of the compilation.
Maybe 15th August may be better, Malus, but I'll leave it to
Anti-profiting batch we can exclude, but amongst gaming, no segregation, my lord. Everything has to be heard here.
Agreed. My friend is right, Manoj.
15th August may be better.
This exercise has been done in the registry.
Yes.
The gaming matters we've got separately listed and the anti-profiteering
Yes.
matters are separately.
Correct.
So
Lordship.
they have to be segregated. Now, what we will do is that the learned counsel can, this is being done by Charanya.
The list is made. Charanya has
Have
made.
you looked at it?
Just check it up now. Just give it to me now.
All right, Ms. Charanya Lakshmi learned counsel appearing on behalf of the petitioners, some of the petitioners, has prepared, has prepared a tabulated statement segregating into single invert commas, gaming into invert commas, matters from into single inverted commas, anti-profiteering matters. Full stop. The statement is reproduced below. Copy kar lijiye. Mr. N. Venkatraman, learned ASG, states that he will have this duly verified within the course of within a week. And intimate the registry in regard to whether he agrees on whether the statement reflects if the correctness of the statement. Full stop. This may be communicated to the court master no later than by date de dijiye on the email ID. The compilations are ready.
The counter, and the counter was received by us in the writ petitions on Monday evening. So we need some time to file the rejoinder.
If a rejoinder has to be filed, that may be filed on or before 31 July 2024.
Lordship, some of the transferred matters, the councils indicated that they would also like to make written submissions when we checked with them. So they were waiting for direction.
All right. If any further written submissions are to be filed, including the transferred cases, they may be filed with the nodal counsel who will refer to the common compilation. So the written submission shall not exceed 5 pages each. Because
would your lordship set it down on 31st for directions?
Absolutely.
Would your lordship have it on 31st for directions, Manoj?
We'll have it on the 31st of July for directions. For the directions on the 31st, which is a Wednesday.
Lordship,
please. Taken first.
All right.
Directions.
My lords will segregate it as they come.
We are segregating gaming and the two sets of
anti-profiteering.
be taken
There
separately.
is no difficulty in segregating gaming and anti-profiteering. Now, any
That's
segregation within gaming is not acceptable.
That's
No,
all.
no.
So we are not asking for it
No,
now.
somebody last time said game of skill should be segregated.
Mr. Venkatraman, now you're giving them ideas.
Yes, correct.
No games.
Nobody is ready for now.
All right, now, so that covers 4, 19 and 20.
Anti-profiteering some date.
So 31st of July, we'll keep it for directions.
Yes.
Just to ensure that everything is complete, then we list it immediately and hear this.
Great.
Obliged, obliged.
Lordship.
Matter, because this is for the gaming matter, now the counter, etc. we have prepared. For anti-profiteering matters, there are no directions in terms of
The circular.
permission
Right.
to
So
file.
for the anti-profiteering matters, we'll issue similar procedural directions, same nodal counsel,
Can be then.
same nodal counsel, same. And by 31st July, that process must be completed.
We can do
All
that.
right?
Publish it.
That is neat.
Please below this.
Mr. Agde, we'll now stand back the income tax matters. We are not adjourning it for the day, but in view of the importance of the NEET matters, we'll take up the NEET matters, because but all the other learned counsel may step aside and you can have a little time off, but we'll take up the income tax matter because we're not taking up any other heavy matter until we take up that. So NEET only because of the social ramification, we thought we'll give priority to the NEET matter. All right, now.
They're all mixed up. 5, 7, 9 and all that.
Now, who's going to open the arguments in the NEET matters for the petitioners?
Manoj, my item 5 is slightly on a different footing. I am showing not merely the leakage of the examinations, but I am showing the.
Because mine is the first matter wherein the.
Mr. Dwivedi, where are you appearing in this matter? Judge's pension matter. I think you're safe today because, if after this, we are going to take up the parted tax matter, which will take the rest of the day. So, but the judge's pension matter is again important and we will take it up probably next week. We'll list it and take it up. Just a little adjustment of the board, that's all.
So far as item 7, if allowed, I can. The writ petition under Article 226 of this candidate is pending before Honorable High Court of Delhi. He has filed writ petition under 32 before this Honorable Court also, saying that I'll withdraw that. This is the third time consecutively where he is alleging that my OMR has been replaced, which is actually.
All right.
That
we will see what to do there, because that's not about the systemic issue, but about his own OMR sheet. There we may be, who's appearing, which one is that serial number?
Item 5. 514.
So 5, why don't you do this? Go to the High Court. Whether your OMR sheet has been replaced or not, there is not a systemic issue.
High Court has already passed the judgments. High Court has refused to examine this issue. My lord, I had delegated.
So why have you
back
filed a writ petition? You have to file an SLP then.
No, my lord, in 2020, I went before Honorable High Court on the directions of this Honorable Court.
But now High Court is held against you.
In 2021.
21 hoga, 20 hoga, 19 hoga,
Now,
23
my
hoga.
lord, since then.
But now tell us, what remedy do you have against that judgment of the High Court?
Against that, even if I come in SLP, my lord cannot grant me an admission. My lord, I am saying I reappear in the examination in the.
Fair enough. We'll entertain your writ.
Yes.
On one condition, that now then we will treat the order of the High Court as attained finality.
Yes.
So we will then hear your writ on the footing that the order of the High Court has attained finality. So you are taking a chance.
My lord, High Court refused to examine the issues. That's the final.
All right, we'll see. We'll see when the matter is called in.
My lord, may I?
Mr. Nagamutu, we are seized of the matter. We know how important it is. It's about our own retired judges. But we have the NEET matter today, so we'll give priority to the NEET matter today. We just indicated to Mr. Dwivedi, we'll try and accommodate it sometime next week, so we'll take it up immediately. We'll just give me a little time, so I'll just in the evening discuss the board position with the court master, and then we'll fix it because we have to take it up.
My lord, I'm here for item number 6. I have the same prayer that my OMR sheet was replaced and the.
All right, let the matter open up now. If everybody just keeps on giving your individual fact, who's going to open the hearing?
Yes,
open the argument?
mine is the first matter, my lord, where they have filed their responses.
So we'll hear Mr. Huda first.
Yes, my lord, I'll supplement whatever he is.
All right, and then we'll hear the solicitor.
Your lordships had an occasion to go through the second status report.
Yes, we have seen the second
Now
stage.
there is something is crystal.
We have seen the second stage.
Yesterday it was.
Yes, I saw it in the morning today. Aapne bhi dekha. Both my learned brothers have seen the second status report.
Made please, lordship.
This is yours.
Just one suggestion.
Okay.
All my. Okay, to the first play. My lord, in item 5, may I please request that the first prayer is, my lord, that
You're not arguing it. You have somebody before you who is to argue his matter.
they are in item 7 and item 5, I am making a request.
But which is the lead prayer? Which is the lead matter? Are you prepared?